Good morning, everyone. Officially, it's 9:33. So thank you for joining us. It's a pleasure to be with you. We are trying a new version of the law fair. Online, it's probably challenging for young people. So well done to the young people who have managed to join us, and despite the technology and despite, the requirements to protect privacy and so on. If I may just give you some instructions, and then perhaps Lida can repeat the instructions in case people join later. Please use the chat if you would like to say something. We can certainly give you the floor by, letting you speak, but you have to be willing to do so. If you are not willing to do so, just use the chat and keep your camera and your microphone switched off at all time. So I will now take you through some of the materials that we have available at the law school. In order to familiarize everyone with the website of the university. So whether you're a student of the university or not, you will find some useful information into what I'm going to say. So let me try again to share my screen this time. Yes. So this is the Uclan Cyprus website. I suppose that most of you know it already. And this is the welcome page of the School of Law. It explains to you all the programs we have in the law school. So we have an LLB, of course, and we also have 3 LLMs, and we have, through Uclan UK, PhD programs. But it does much more than this. There is a long video if you want, if you're keen on watching the long video. There is also the annual review of all the events we did in the academic year 2018-19, which is very helpful if you want to open it. I'm not going to open it here because it's a bit big, but it has very nice pictures, it has a very nice text, and it explains the philosophy of the school, and it explains how students are engaged. Now, if you go to the right-hand side of the screen, you can click on the courses. And each course is designed in a similar way, the outline. So you have an overview with a very nice animation, which you can watch, which is very, very short, and a description of what the LLB offers. But then you can go to the actual modules of the program. You can see some of the members of faculty of the program, and you can click on their profiles, as you can see. You can see what we do in terms of professional development in the School of Law, and there is a lot to say. And then we have created a tab on student experience, and where you can actually see quite a few videos of interesting events we had and how we promote basically student engagement and student experience. Here you can see our mood court room. We would have been in the mood court room today had we been on campus. And the same applies to the postgraduate degrees, such as the LLM in law, but also the other specialized LLM. So it's the same structure, you see, with nice animations as well. But I just wanted to pay attention to professional development, which is slightly different on the LLM, because of course, postgraduate degrees are different. As you can see, we have external partners on the LLM. We run courses that are aimed at qualifications in the field of mediation internationally, but also arbitration with our partners, and through Uclan UK for the arbitration. And we also do a lot of CPD, continuous professional development, which also applies to our students. Some of it is for LLB students as well, but most of it is for LLM students and professionals. Again, here you can go to employability, and you can see the type of employability events we do, with a long list of these activities here, and the same videos as on the LLB. Now, since I spoke about CPD, I am now going to turn to the right-hand side of the screen, as you can see, and take you to what we know as the Law Academy. The Law Academy is our webpage to share with the public all the professional courses we do. So, for example, you see last year we had a series on law and technology. You can see many previous courses. You can see new courses. Okay, they put the lawyer for a day here. It's not really CPD, but anyway. There is a forthcoming mediation course, as I said, in February 21. This is open to LLM students, but also to externals, and we usually have lawyers taking it. And this semester, this semester and finishing today, we have a course which is open to LLM students on EU constitutional law and governance in populist times. I will come back to that in a second. Now, I wanted to show you a couple of more things so that you can see the sort of resources you can use. So I came back to the School of Law's opening page, and let's visit the law blog. So the law blog is primarily run by the students, for the students and the public. I said primarily because, of course, we are assisting. And you can see the team of the law blog. There is an academic editorial team here. This is the current academic editorial team. We do this in rotation. But we also have a students team. And for this year, you can see who they are, Katerina and Angelina. Now, the law blog is open to everyone to be able to use it and write short blogs. So you can see here, for example, the type of blogs we can have. Students sometimes engage in interviews with high-profile experts, such as Ms. Androula Vassiliou, who used to be the EU Commissioner for Education, but not only. We have lawyers writing. So this is by Harilaos Velaris, who is a lawyer who cooperates with the school. This is also by a lawyer, Andreas Hagigeorgiou. Ourselves, we sometimes engage with the law blog if we want to pass on a message to the students in particular. So these are real resources that you can use in your assignments and your understanding of what the law is. So we had a series on COVID. During lockdown, we were all particularly concerned with the situation. So we addressed several issues of the COVID crisis. And you see those very nice pictures. They were actually designed by an alumnus of the School of Law. This is by a PhD student. So you see PhD students, and that's Andrea, are also involved. The one on Auschwitz, we have a series of blogs on Auschwitz because we had the privilege of being able to take the students twice on a trip, on a remembrance trip to Auschwitz, and students were so involved in what we were doing that you know, they shared their experience prior to the trip and after the trip. But then we have simply, you know, students. That's again an interview. We also have students writing. You see, that's from Daniela Mura. It's on gender pay. She was an LLB student. She now graduated. And this is from an LLM student. It's about Auschwitz and so on. So I would like to encourage you to use this. There is a second resource which you might find useful on the law blog, which is the rule of law monitoring mechanism, which is something recreated amid the COVID-19 crisis, the pandemic. And here we are only interested in the rule of law. So you will find the blog posts that are relevant to the rule of law here. But you will also find other resources, such as videos, that have to do with the COVID crisis and human rights and what's happening for businesses and law firms, or what's the situation in the EU and the UK. So please, you're welcome to watch all this. And also, I wanted to show you basically that you can find further resources on the rule of law monitoring mechanism. If you click here, you will find major events that were held at the law school and that involve high-profile experts such as judges, national court judges, but also EU court judges, but also funded projects. So I would like to take you to 2 funded projects. One that is completed. This is a Jean Monnet module on the financial crisis that was completed a couple of years ago, and it was actually identified by the European Commission as a success story. If you click on the publications, you will find quite interesting materials on the financial crisis, and this is very helpful for the LLB and LLM students who are doing projects in particular or dissertations that are relevant to the financial crisis. So please don't hesitate to check the resources out. Of course, you can see the booklets. We have working papers, but we also have a long series of events, and you can click on the events and find out what it is that we were doing. There are usually press releases as well. So that is the first project that I wanted to show you, but I wanted to show you another one, which is basically, so now I am in the research tab of the university, as you can see. And I will go first to the research profile of the School of Law. You will find a reference to the law blog that we have already seen. You can see the annual review. You can see the Jean Monnet module that I just spoke about now. And we also have a Jean Monnet module, which is currently running at the school. And this is the one we are having today, actually. So I will have to leave you because I will have to teach in that Jean Monnet module, while Andreas will join you at the law fair. So we exchange basically positions. This is an EU law module, related module on EU and populist times, and it has its own website. So if you click here, you get to the website of EUPOP, which is the name basically, or the acronym of the EU project. And on that website of EUPOP, actually, there is a lot of very useful resource that you can use. So EUPOP is composed of a specific team. Well, okay, other than myself, you can find early care researchers, PhD students like Andreas, Marco, who you will meet later, and who is going to talk to you about populism. So Andreas, but we also have external guests and experts. Natalie, who used to be our colleague, but has now moved on, but stayed with us for the project. And some experts from the Netherlands and from the EU institutions, as you can see. So I would, if you're interested in being informed of EUPOP, well, it's very easy. All you need to do is subscribe here. You see the subscribe button. You can subscribe to the newsletter. You can follow us on Twitter and on Facebook as well. Now, in terms of activities and resources, very quickly, activities are all written down here. So, for example, the LLM module that I'm talking about now, which is also open to externals, is here. We have a series of webinars, and the actual webinars can be found on the website. So I would encourage you to look at this. We ran a summer school in September, and very soon all the materials of the summer school will be on the website, including videos, video by Nasia, but also other materials. And there is an explanation of the project, of the Remembrance Project for Auschwitz. And we do, of course, guest lectures. This one was the first one that was in the context of the summer school. Now, as I said, we have a media tab like the law blog. And in the media tab, you can find not only interviews, but you can also find podcasts and webinars. And finally, for those who are going to research into the field, If you go to bibliography, you will find a long list of open access resources in the field of the rule of law and populism. So please feel free to use those resources. They have been collected by researchers of the project, and it's a lot of work. So we would be happy if this is of any use to anyone. Finally, EUPOP also publishes a journal, and the journal has its own website simply because we have to, give information about contributions. So we invite students and members of the public to contribute not only to the law blog, small blogs, but also if you are embracing a more academic career, then EUPOP would be the journal for you, provided you want to work along the lines of the European Union, the rule of law, and populism. And it's possible to submit short essays as well as longer papers. The process is described here. Okay, so you see with the article types and the length of the contributions. We are currently working on the first issue of the journal that should be out in January 21, and soon the call for the second issue of the journal will be out. So that's more or less what I wanted to say. So let me unshare my screen. I hope you found it useful, no matter who you are. Can I ask if I have unshared my screen properly?
You have, Stefan.
Okay, thank you very much. Nidamu, I'm not sure what's next on the program. I just remember that I had.
So thank you very much, Stefan, for the welcome address. Now we're going to have Dr. Nasia Hadjigeorgiou, who is the assistant professor in transitional justice and human rights. She will do a session on criminal law, particularly how to get away with murder. So thank you very much, Nasia. So you can start.
Hi, everyone. I hope you can hear me properly. So let me just say that I have already uploaded 2 documents for you to look at in the files. One is the PowerPoint presentation, and the other is a handout that you can use to follow what we will be saying today. I seem to have, okay, so let me just share my screen first. So the plan for today is the following. I know that some of you are familiar with criminal law, and I know that some of you are not. So we will start from the assumption that you all want to know the basics of criminal law. So we will look at the basics, what we call the actus reus and the mens rea for all crimes, and then we will focus on criminal law. And since the objective is to get away with murder, we will look at some of the defenses that are potentially available to murder, and in particular, the defense of consent. So if we are to start with the very basics of criminal law, in order to prove a crime, if you're the prosecution, you bring someone to court and you want to prove that they have indeed committed the crime that you're accusing them of, you need to prove 2 things. The first thing is that they have committed the actus reus. Now, the actus reus is the actual act of doing something illegal. The second thing you need to prove is that they have the mens rea, what we call the guilty mind. So for any crime, it doesn't matter whether we're talking about murder, whether we're talking about manslaughter, whether we're talking about theft, about rape, about fraud, about causing actual bodily harm, about burglary. So for any crime, you need to prove 2 things. You actually need to prove that the defendant was doing something, okay, which for each crime is different. For murder, it would be the killing, for example. And you also need to prove that the defendant was thinking of something, okay, and that is the mens rea. You need to have both, and you need to have both at the same time in order to have a crime. If one took place 2 years ago and the other is taking place today, that's not a crime, okay? So I will be using examples throughout in order to explain what I mean by that. Let's start focusing on the law of murder, and this theory of the actus reus and the mens rea should start making sense. Okay, so let me say a few preliminary things about murder. Murder is, in English law, the most serious crime together with treason. Okay, we don't get many cases of treason, so let's focus on murder instead. Murder is the only crime that attracts a mandatory life sentence. Now, what does that mean? It means that if the jury, because in the UK we have, for criminal trials, a jury system, if the jury convicts the defendant of murder, the judge, who is the one who decides the sentence, he's the one who decides how long the convicted person goes to prison for, the judge does not have any flexibility. He has to send the convicted murderer to prison for life. This is what we call a mandatory life sentence. Okay? This is not the case for any other crime. So, for example, if you take, I don't know, the crime of assault, okay? According to Section 39 of the Criminal Justice Act 1988, the crime of assault is punished with a maximum penalty of 6 months in prison. This means that the judge can decide whether to send the convicted person who has committed assault to prison for 1 day, for 2 days, for 4 days, for 10 days, for 2 months, for 5 months, or for a maximum of 6 months. So he has full flexibility. The only thing that limits his flexibility is the ceiling. Yes, the fact that the absolute maximum that he can give out is a 6-month sentence. The same applies, for example, if you commit causing grievous bodily harm with intent. In other words, injuring someone very seriously, intentionally. Now, the judge in that case has the discretion, in other words, he has the flexibility, he has the power to convict someone with anything from 0, so 1 day, to life imprisonment, depending on how serious the harm that has been committed actually is. So he has this massive flexibility from 0 to life, okay? And it's for the judge to decide where on the scale these defendants should fall. With murder, things are different. The judge does not have any flexibility at all. If the prosecution successfully proves that the defendant has committed murder, the judge's hands are tied and he has to give out a mandatory life sentence. Okay? Now, the other thing that I want to say before we actually start talking about how to prove the existence of murder is that murder is different to manslaughter. Now, there are many different types of manslaughter. So there is what we call gross negligence manslaughter, there is what we call constructive manslaughter, reckless manslaughter, voluntary and involuntary manslaughter. We will not look at any of those, though those are pretty complicated. If I have piqued your interest with murder, then you're more than welcome to join the LLB and you can find out all about the manslaughter charges when we're covering the full criminal law course. Okay? So, as I said at the very beginning, in order to prove any crime, you need to prove the actus reus and you need to prove the mens rea. Now, what is the actus reus of murder? As we said, the actus reus is the actual act of doing something illegal, and for murder, that is the act of taking someone else's life. Okay? Now, what you need is, this is very straightforward. You need a living, breathing human being, and you need them at the end of the act to be dead. Okay? Now, in the majority of cases, this is straightforward. If I kill my husband, I have committed the actus reus of murder. If I kill Stephanie, I have again committed the actus reus of murder. There are, however, some more difficult cases. So the difficulties have to do with the very beginning of life and the very end of life. So when does life begin? If I kill a baby who is a day old, so he was born yesterday and I kill him today, am I committing murder? The answer is I definitely have the actus reus of murder because a one-day-old baby is a human being. But what if I kill an embryo? What if I kill not a baby, but a baby in a woman's womb? The law says, and I appreciate that some of you might disagree with that, but that is what the law states. The law says that that is not murder, okay? And the reason it's not murder is because life begins at the first breath, okay? So if the embryo is viable, in other words, if it's a 9-month-old embryo and it dies, that's not murder. It might be another crime, terminating the unborn life, but it's not a crime of murder. Okay. Now the other difficulties have to do with the very end of life. So what if I kill someone who is in a coma? Or what if I kill someone who has 30 minutes to live or 30 seconds to live? Is that the actus reus of murder satisfied? That is slightly more complicated, but as a general rule, even if you just kill someone half an hour before they were anyway supposed to die, you are committing murder, okay? So that's the actus reus of murder. As I said, in the majority of cases, pretty straightforward. If there is a human being and then he's dead, you have committed the actus reus. Now let's go to the mens rea. What do you need to prove in order to prove the mens rea of murder? Well, the defendant must intend to take the life of another person, or the defendant must intend to cause really serious bodily harm. Now that is important because you can commit murder in two different ways. If you kill someone and you wanted to kill that person, so the classic example of that would be a hitman, okay? So I, for example, go to my friend Lida, I tell her, Lida, here is €1 million, I want you to kill Klearchos, okay? So Lida takes the money, she prepares her, I don't know, her way of killing Klearchos. Let's say she's going to shoot him in the head, okay? She prepares the gun, she prepares the bullets, she makes sure that Klearchos is alone in his office, that there's no one around. She goes in his office, he looks at him in the eye, and she shoots, okay? That is murder because, one, Klearchos is dead, the actus reus of murder has been satisfied, and two, the mens rea of murder has been satisfied because she intended, she wanted to take the life of the victim, okay? But that is not the only way in which you can have murder. You can also have murder if you kill someone and even though you didn't want to kill them, you wanted to cause really serious harm. So the classic example of that would be a bar fight, okay? We are in a bar, we've all had a couple of drinks. We're not drunk, but we are happy. So we've all had a couple of drinks and this guy accidentally pushes me, okay? So he accidentally pushes me, I push him back, he pushes me again, I push him back, and he says, I'm going to kill you, let's go outside, and he doesn't say, I'm going to kill you, let's make this simpler. He says, let's go outside, we will fight this out, okay? So we go outside, he throws the first punch, I kick him in the head, and he falls back, okay? And he hits his head on the pavement. I did not want to kill him. All I wanted was to seriously harm him. I wanted to break a bone. I wanted to humiliate him, to teach him that that is not a way to treat a lady in a bar, but I did not want to kill him. Okay? Yet, he's dead. Now, if I had killed someone with the intention of causing really serious harm, but not killing him, I am still a murderer. Now, is that clear for everyone? Do we have any questions? Now is the time to speak up. You don't need to use the chat here, just talk. If you have a question, feel free. Okay, let's assume that you are all clear about that.
Miss, I have a question.
Tell me.
It's in regard about the example that you mentioned about the embryo. In regard to England and the courts, I think I read a case in regard to the definition of an embryo, and wasn't it decided that the first heartbeat, the embryo is considered a breathing being?
No. Okay, so let me clarify that. An embryo has rights, okay? It's not that an embryo is non-existent in the eyes of the law. So if, for example, you have an abortion and you don't follow the correct procedure, and the correct procedure basically requires that you get the permission from 2 doctors and you do it before the 24th week of pregnancy. So if you have an abortion, say in the 28th week of pregnancy, and you don't ask a doctor, you just have an abortion at home, that is illegal, and you are committing a crime, because what you are essentially doing is violating the rights of the embryo, okay? And the reason we are protecting the rights of the embryo is because the embryo has, as you said, is a living being, okay? But that embryo does not have the same right as a human being, okay? So the embryo will have the right to be protected under certain limited circumstances, but we do not treat that thing in the womb as a human in law. You only treat a person as a person as soon as they have taken their first breath outside of the womb. Is that clear?
Yes, thank you very much.
Do you have any other questions from anyone else?
Nasia, we do have some questions on the chat if you want to check them.
Okay, give me a second.
Yes, I also have a question.
Tell me.
What about if it's intended to harm a person, but as a self-defense? Usually when people get harmed, they want to harm back, but as a self-defense, will this also count as a murder? I mean, does it change?
So that's a really good question. If you, actually I can answer it now. The answer to that is the following. Say, let's make this a bit realistic, okay? So I'll give you a practical example of this. I am walking down the street and I am carrying a knife, okay? And you know, I'm a woman and I'm not particularly large. It's night time. I see a large man approaching me, and it's very clear that he's about to attack me. Okay, he I don't know, has a gun and he's about to start shooting at me. Now, if I take out my knife and I throw it at him and I kill him, I satisfy both the actus reus and the mens rea. Why? Because I have killed someone, that's the actus reus, and I wanted to kill someone, that is the mens rea. So technically, murder has taken place. After we have proven that the murder has taken place, however, we can still go on and say, however, there is a defense here, okay? And that defense in this case is self-defense, okay? And the law says that if you kill someone in order to protect yourself, and you have not totally overreacted, then it's not a crime. Okay, so an example where I have totally overreacted would be the following. I am walking down the street, I see a man, he's really far away, he's approaching me, all he wants to do is ask for directions, and I think he's about to kill me, so I kill him first. He has shown no signs of aggressiveness, but I nevertheless kill him. There, I can argue that I was acting in self-defense, but I wasn't really, because it was a total overreaction. So as long as you're not totally overreacting and you are acting in self-defense, technically you are committing murder, but the defense of self-defense kicks in and you are protected. You will be found not guilty. Does that answer the question?
Yeah, so basically we have to prove that it was self-defense in order to not, yeah, okay.
Correct. Okay, so we have a couple of questions. Sorry, Sophie, I just saw your question in the chat as well, so I hope I've answered that. Then we also have a question from Joya. If someone threatened and obliged me to kill someone, my sentence will be reduced as I was obliged to kill the person, or they will kill my mom. Okay, so again, this is an example that has to do with defense. So basically what Joya says is the following. What if someone goes to my mom's house, kidnaps my mom, says, and then gives me a call and says, I have your mother. If you don't do what I say, I will kill her. I want you to now go kill the president of the republic, or I want you to kill your neighbor, or whatever. That is the defense of duress. Okay, and the law says that the defense of duress is unavailable for murder. In other words, if they have your mom or your dad or whoever that you love hostage and they ask you to kill someone, otherwise they will kill them, the law says, and I know it's harsh, but it is what it is, you have to let them die. The defense will not protect you at all. This is a very, very strict rule. Okay, and then we have another question from Andreas. What happens if you have a serious mental illness and you kill someone? Okay, so there are two ways of looking at this depending on. Okay, so let me give you the answer. If you can argue one of two defenses. The first defense would be insanity. The problem with insanity is that if you successfully argue insanity, you are not sent to prison, but you are sent to a psychiatric facility. Okay, and it is up to the doctors at the psychiatric facility to decide when you will leave that facility. So you might stay there for 3 months, or you might stay there forever. Okay, insanity is not very popular because yes, you're not going to prison, but you're not going home either. Okay. The other defense you can use is a defense called diminished responsibility. And there you're making the argument that I have basically diminished responsibility. I'm not totally to blame for this because I had a serious illness. Again, that is a defense that is used, but it's not a great defense because even if you successfully argue diminished responsibility, you can reduce murder only to manslaughter. Okay, you can never be found not guilty because you have argued the diminished responsibility. It only takes you halfway there. Okay, it only reduces murder to manslaughter. And you might be thinking, well, what's the point? Well, the point is the sentence, because you remember that with murder, the sentence is a mandatory life imprisonment. You stay in prison forever. But with manslaughter, the judge can decide. He has flexibility. So if you were convicted of murder, you would be in prison forever. But if you are convicted of manslaughter, you might leave prison in 5 years or in 10 years or in 15 years. If you're a 20-year-old and you have committed murder, it makes a difference if you're there for 80 years or if you're there for 10. Okay, so for serious mental illnesses, you have these two defenses, insanity and diminished responsibility. None of them are as effective in getting you out of prison as, say, for example, the defense of self-defense, which is a total defense and you just go home the next day, but they are something. Okay, one more question in the chat. If the person has a mental illness and kills someone, they will plea as insanity and the judge will give him time in a psychiatric hospital, right? Yes. It's slightly more complicated, but for the purposes of this class, let's just say yes. So if you have what the courts have called an abnormality of mental functioning, then you can argue insanity and the judge will ask that you're sent to psychiatric facility instead. Okay, ladies and gentlemen, do we have any other questions or shall I move on? Okay, I will be reading out the scenario and you let me know, guys, what you think. Is it murder? Is it not? So, first scenario, Andrew fantasizes about killing his ex-girlfriend Barbara, but he never goes through with it. Is Andrew a murderer? Okay, so who can take this on? What do you think, guys? So, Sophie says no. Why? You're right. It's not murder. Why? So let's break this down to actus reus and mens rea.
To become a murderer, you need to successfully pass these two acts, but Andrew passed only the act of thinking about harming a person, but he never actually acted it. So basically, he cannot be called a murderer.
Excellent. Okay, so he has the mens rea, but he does not have the actus reus. And as we said, you need to have both, and you need to have both at the same time. Otherwise, you're not committing the crime. So let's go to the second one. Charlie is driving his car and accidentally hits Debbie. He had been going under the speed limit and was following all traffic laws. Is he a murderer? Now, let me say that Debbie is dead. I mean, it's not obvious from the fact that he hit her and he died, but she is dead. So who is going to let us know? Is that murder or not? Andrea, you need to unmute your microphone and let us know what you think.
He is a murderer because he killed a person, but he has not committed a crime because he doesn't have the mens rea. He has the actus rea.
Okay, so he's not a murderer then. Yes, because yes. In order to be a murderer, you need to have both the mens rea and the actus reus. So you're absolutely right that he killed someone, so the actus reus is there, that is dead, but he did not have the mens rea. He did not intend to kill her, and in fact, he was very careful. He was going under the speed limit, and he was following all traffic laws. So what we have here is not murder. What we have here is an accident. Okay. Now let's go to the third mini scenario that I came up with. Elaine hated George, but never planned on killing him. One day, she is drinking her tea made up of exotic herbs, and George asks to have some. Okay, so he wants to have some tea. She gives the tea to him, he drinks some, and immediately he has an allergic reaction and he dies. Is Elaine a murderer? Now, this is more complicated. Who is going to give this a go? So, who do we have here? Kyriakou?
Yes.
Hi. So, is Elaine a murderer?
I think she's a murderer because George dies.
Okay, so we have the actus reus. She gave him something that killed him. Essentially, she poisoned him. Yes?
Mm-hmm. Yes.
Okay. Do we have the mens rea?
No.
No, we don't. So if you have the actus reus and you don't have the mens rea, is she a murderer?
Not.
No. Okay. So she hated him, so she might have wanted him to die, but she never planned killing him. Okay. So for example, I might hate my brother, but if I never plan on killing him, I never have the mens rea for murder. Now, if one day something happens and I accidentally kill him, which is what happened here, she had no idea that the tea would poison him. Okay, so basically, she was a bad person who was lucky, okay, because she ended up killing someone she hated, but she was not a murderer. Is that clear? Do we have any questions, guys? Andrea, you have your hand up. Is that because you want to ask a question or because you forgot to lower your hand from before? Andrea Papandreou. Okay. Yes, you have a question. Let me know.
So in this example, what happens to Aline? Is he committed for? Did he commit a crime at all?
No, that's a really good question. So in this example, what happens to Elaine? Has she committed a crime? The answer is no. She was just involved in an accident. In the same way that if I don't know, if I cook fat chicken and I feed it to my neighbor and he dies, if I had no idea that the chicken was poisoned, this is just an accident. It's a horrible, sad story, but it's not a crime.
So she's not accused for any crime at all. She will be
correct.
Free. Okay, thank you.
Yep. Okay, let's go to the last one.
So,
oh, sorry, there was another question.
Yeah.
Tell me.
So she won't be prosecuted at all?
She will not. Well, I don't think she will be prosecuted at all. It depends. It very much depends on the case, and the prosecutor decides who he takes to court. If I was the prosecutor, I would not take her to court at all, because I know that I will lose.
So it's not manslaughter.
Let me think. Was she? No. This is not manslaughter either. I mean, we haven't covered the law of manslaughter, so you will have to believe me when I say it's not manslaughter. But it's not. It's just an accident.
What about the Charlie case?
Sorry?
What about the Charlie case? Is it manslaughter or no? Because it accidentally happened as well.
No, it's not manslaughter. That's just an accident. Because he was going under the speed limit and he was following all traffic laws.
Okay, thank you.
Okay? Okay, so let's go to the very last scenario because there's still one more thing that I want to say when we finish with these. Harry is very upset with his girlfriend Indra because he found out that she was cheating on him. He punches her in the face, intending to hurt but not kill her. She stumbles and falls awkwardly, hitting her head. She dies 2 days later in hospital. Is Harry a murderer? Who's going to give this one a go? Yes, Kirsten.
This is like the bar fight example. He intended to harm her but not to kill her, so this is mens rea.
So he had the mens rea. Did he have the actus reus?
Because later she died, he did not intend to kill her, but he did harm her and put her in the hospital.
Good. So since he has the actus reus, he ultimately killed her, and he has the mens rea. He had intention to cause grievous bodily harm. We have a murderer.
Yes, so he becomes a murderer.
Good.
And now the judge will say his sentence, right?
Yes, but the judge doesn't have any flexibility. The judge has to give him a mandatory life sentence.
Okay.
Good. Do we have any questions, ladies and gentlemen? Yes, Andrea.
I think in Cyprus many years ago, if you committed a crime for your own honor, for example, if someone raped your daughter, something like that, and you committed a crime and you killed him, the judges will not find you guilty in Cyprus. I don't think. I don't know. Is this?
Okay, so Cyprus has a different classification. So while in the UK they have murder and manslaughter, in Cyprus we have φόνος εκ προμελέτης and anthropoctonia, and the two are not the same. So I wouldn't want to go into too much detail about Cypriot law because it is very different to English law. But my understanding is that yes, you will still be guilty, even if you killed someone because you were provoked.
Isn't this what we call in Greek emvrasmopsychis?
Still, it's what I just called in English provocation. And provocation is only a partial defense. So it's like the defense of diminished responsibility that I described before, that it reduces a finding of murder to a finding of manslaughter. So you would still be guilty, and you would still go to prison, but you would just go to prison for less time. Okay? Sophie.
Yes, as far as I know, the mandatory sentence is different in every country. I mean, it doesn't mean that he will stay there forever, but it can be like 25 years, right?
Yeah, so actually that's a really good question. A mandatory life sentence doesn't actually mean that you stay in prison for the rest of your life. It means that you will stay in prison for many, many, many years, and then you are eligible for parole. Okay, and if you are successful in getting parole, then you leave prison. But if you commit any other crime, you go back to prison automatically for the rest of your life. That's what mandatory life sentence means.
Oh, okay. Thank you very much.
You're welcome. Okay, guys, I only have 3 minutes left before 10:30 when the session is supposed to end. So I have a slide, a theoretical question for you. You all mentioned defenses that you think could be applicable. So you mentioned self-defense, you mentioned duress, you mentioned diminished responsibility, you mentioned insanity. Andreas just now mentioned provocation, what we call in English loss of control. None of you mentioned consent. Okay, so let's talk for 2 minutes about consent. Now, consent is what if you kill someone because that someone asked you to kill them? We know that consent is a defense in other crimes. So to give you an example, intentionally causing grievous bodily harm, okay? I kind of mentioned grievous bodily harm before. It's this idea that you cause really serious harm to someone, okay? So imagine I take Andreas, I tie him on a bed, okay? I inject him with something so that he falls asleep, and then I cut him open. That is the definition of grievous bodily harm, yes? Now, if Andreas had said, yes, please, tie me on a bed, inject me with something, and then cut me open, that would not be grievous bodily harm. That would be a surgery, okay? That is what happens every day in hospitals. You consent, you sign a piece of paper that says, yes, I want the doctors to essentially cause bodily harm to me because I consider it necessary. That is the defense of consent, okay? Or let me give you another example, boxing. Yes, a classic scenario, punching someone is a criminal offense, but boxing is not illegal. Why? Because both participants agree, okay? Or let me give you another example, tattooing, yes? Tattooing is, I don't have one, but I understand it's when you are skin is burned permanently with a design. Now, if I was to take Eva, sit her on a chair and start burning her skin, that would very definitely be a crime. But if I am a tattoo artist and Eva wants to get a tattoo, so she has consented to this, it's not a crime. So we know that the defense of consent exists, but the question is, does the defense of consent apply to murder? Or is it like duress that I mentioned before when I said, yes, the defense of duress exists, but it does not exist to murder? So if let me give you a realistic example. If my husband is very ill and he is in pain and he knows that he will die in the next week, so he is, for example, in the very last stages of cancer, he knows that he will die, he knows that it's not treatable, he is in massive pain, and he just tells me, just end it now. We will just say our goodbyes now and just put a pillow over my head and I will go to sleep and I will not wake up again. Is that murder? What do you guys think? Sophie, you have your hand up. And then Eva.
Yeah, maybe if he signed it, it would be legal, but just in words, it doesn't really prove that he wanted for you to kill his life, take his life.
Okay, so that's one idea. Eva?
Isn't that assisted suicide in a way?
Because what I described is actually euthanasia, but assisted suicide is not very different from that. So is euthanasia legal? What do you think? Yeah.
I think it's illegal.
Okay, why?
Because you have both the mens rea and the actus reus. So
You're
these
right.
are the criteria to...
But you have the mens rea and the actus reus for self-defense as well. And we said, yes, we have the actus reus and the mens rea, but there is a defense here and we will rely on the defense. So the question is, can consent or should consent be a defense? Kristin, and you will be the last person to speak because I have already overrun by a few minutes. So okay. I'm sorry, everyone else has already spoken. So Kristin, one last time, and that's it. Yes.
Prosecution might argue that maybe he wasn't in his right mind, and this is taking advantage of a man.
Yeah, actually, that's a good argument. So let me guys give you the answer to that. In English law, euthanasia is illegal. Okay, so in English law, you can never consent to being killed. As my lecturer 1,000 years ago when I was in university put it, it doesn't matter if the victim says, please don't kill me, or if the victim says, please kill me. Okay, both cases are illegal and the defendant would be guilty of the same crime, that of murder. Okay, that's it. I hope I have given you some insights into criminal law. I hope those of you who are not our students have liked it enough to come and join us in the future. Those of you who are students and who have not taken criminal law yet, I will see you soon. Have a nice rest of the day. Bye from me.
Thank you very much, Nasia, for that interesting presentation. I'm sure the students have found it as well very interesting. Now we are moving into the next session, which will be held by Dr. Klearchos Kyriakidis, who is the Assistant Professor in English Law and Legal Practice. He will do the session entitled, What Does the COVID-19 Pandemic Have to Do with Law? So Klearchos, if you would like to start, thank you very much.
Right, first of all, thank you to you, Lida, for organising and chairing today's law fair. It's an honour for me to participate. I've decided to say something about a subject which concerns me personally and professionally, and it's the question of what does COVID-19 and the pandemic related to it have to do with law? Well, I've spent the last few weeks and months teaching with this in front of my face. I'm at home now, so I'm free, I hope, to not teach with this mask on my face. I also have very close family and friends in the United Kingdom, which has acquired the very worst death rate of all of the 31 European states that are monitored by the European Centre for Disease Control. That is the 27 member states of the European Union, plus the United Kingdom and a sprinkling of other non-EU member states. I'm also affected by the pandemic in common with all of you because I'm restricted in what I can do in terms of where I can go and what time I can do what I want to do. And I'm furthermore hoping that the authorities, the governmental authorities, are doing everything that they can to protect my right to life. So that's a little bit of background to what's going to follow. I'm going to try and explain to you how me personally, but also you as students, are affected by this pandemic. I'm going to focus on the situation in England, which is one of the 4 countries in the United Kingdom. I'm going to focus on England because I'm not qualified to comment with any great authority on the law of the Republic of Cyprus. But I have experience of English law and I teach English law, so I'm going to focus my remarks on England. Also, the situation in England is extremely interesting because it stands in very sharp contrast to the situation in the Republic of Cyprus. I'm not saying that the Republic of Cyprus has handled the pandemic brilliantly, but it's handled it less terribly than the United Kingdom for reasons that we'll see over the next half an hour or so, maybe 20 minutes or so. Now, those of you who know my teaching style, I teach in the Socratic method, so I welcome questions from students. So those of you who wish to fire a question at me, to criticize me, or to seek clarification on something that I've said, please feel free to step in and ask your question or send a message through the messaging system. So let me just begin with this map of the United Kingdom of Great Britain and Northern Ireland. I'm going to focus on England, and that is because England is subject to its own legal system. It has a judicial system that's shared with Wales, but Wales used to have a legal system that was shared with England, but since the establishment of the Welsh government and the Welsh Parliament, Wales has increasingly developed its own semi-separate legal system. Scotland has its own separate legal system and has had for many years, so too has Northern Ireland. So even though the United Kingdom of Great Britain and Northern Ireland, which is the entity shaded in blue on that map, it constitutes one single sovereign state, for various historical, constitutional and legal reasons, England has acquired its own separate body of law, and I'm going to focus on the situation in England. Let me begin with let me move on rather to discuss the chronology of the pandemic as it affected the United Kingdom. And as I trace that chronology, I'm simultaneously going to flag up some of the legal issues that affected the United Kingdom generally, but more specifically England. Let's begin on the 31st of January 2020. At 2300 Greenwich Mean Time, on that fateful date, the United Kingdom exited the European Union. The European Union is the body that used to be, until that time and date, consisting of 28 member states. For various reasons I won't go into today, the United Kingdom exited the European Union. The Republic of Cyprus remained in the European Union together with 26 other member states, making 27 in total. On that date, a day before that date rather, the World Health Organization issued a warning telling the countries of the world that there was this nasty virus that was spreading from Wuhan in China. It was gradually spreading across various parts of the world, and firm and robust action needed to be taken. The Lancet magazine, the Lancet journal rather, one of the most respected and revered medical journals in the United Kingdom, issued a series of warnings about this terrible disease that was gradually spreading on the 27th of January 2020. But as you can see from the date, the United Kingdom government, with Boris Johnson as Prime Minister, was preoccupied with other things. Brexit, as this phrase of UK exit from the United Kingdom has come to be known, was uppermost in the mind of the British government at this pivotal moment when the virus was spreading. And you may remember that in February, the virus started to spread across Italy and gradually other parts of Europe. Indeed, the first detected cases of COVID-19 hit the United Kingdom at the very end of January, just as this Brexit process was unfolding. So that was a key moment in history, the 31st of January 2020. What the British government, indeed what all governments around the world should have done, but it appears failed to have done, is acted upon what our grandparents taught us when we were children. Prevention is better than cure. I'm sure your parents or grandparents or great-grandparents taught you this very simple principle. Prevention is better than cure. There's an old English saying that's very similar to this: a stitch in 9 saves 9. Benjamin Franklin in the United States said, an ounce of prevention is worth a pound of cure. These are all traditional proverbs, traditional principles, traditional simple ideas, which far too many people around the world, many of whom were supposed to be educated and intelligent, failed to act upon. And as a result of this failure to act upon this very simple principle, the world has ended up in this astonishing situation whereby we have a public health disaster all over the world, on the one hand, with multiple deaths and multiple illnesses and multiple acts of suffering on the one hand, and on the other hand, we have the economies of one country after another collapsing before our eyes, and they're being propped up with massive debts that are being racked up by governments that are trying to keep their economies afloat. And we are the ordinary citizens at the grassroots of society are in the thick of it. So let's now go to the chronology again and look at how the chronology interrelated with law. The World Health Organization issued a fresh warning on the 11th of March 2020. I'll read it to you briefly. This was a critical moment. In the past 2 weeks, the number of cases of COVID-19 outside China has increased 13-fold, and the number of affected countries has tripled. There are now more than 118,000 cases in 114 countries, including the United Kingdom, and 4,291 people have lost their lives. The World Health Organization has been assessing this outbreak around the clock, and we are deeply concerned both by the alarming levels of spread and severity and by the alarming levels of inaction. I stress that word, inaction, for reasons that are going to become apparent in 2 or 3 minutes. We have therefore made the assessment that COVID-19 can be characterized as a pandemic. Now, upon hearing this, some governments around the world, including, I have to say, the government of the Republic, took immediate and robust and effective action. And as those of you who are at our university will recall, we were effectively turning over temporarily to online teaching by the end of this week that the World Health Organization issued this warning. And if I remember correctly, it was by Monday the 16th of March that we were teaching online as a temporary measure to try and limit the risk of the virus spreading and the risk of people dying as a consequence. So that was what was happening in the Republic of Cyprus in response to this very, very grave warning. Over in the United Kingdom, there was a mass gathering of Parliament in the House of Commons, and they were in the House of Commons on that fateful date. And there you see the British Prime Minister, Boris Johnson, who's both a Prime Minister and a Member of Parliament, addressing the House of Commons, and he issued quite a a robust response to what was going on around the world. He said, and I'm reading here exactly what the British Prime Minister said, according to the official transcript, "Our health system is very well managed and very well prepared for this epidemic. I congratulate everybody in the National Health Service responsible on making the preparations." Within a few days, it transpired that the National Health Service was not well prepared. The British government was not well prepared. There was insufficient personal protective equipment, such as face masks and gloves, across the National Health Service and the wider public sector. The British courts, or the English courts rather, didn't have sanitary liquid to protect people who were coming into court buildings. There was a failure of the British state exposed on the 11th of March 2020 and in the days which followed. 12th of March 2020, the Prime Minister issued a press conference. So this was one day after the World Health Organization had declared a pandemic. Can you see there, everyone was sitting next to one another, no social distancing. The Prime Minister was standing next to the Chief Medical Officer to our left, to his right, and the Chief Scientific Advisor to our right and his left, not socially distancing. And look what the Prime Minister said. From tomorrow, if you have coronavirus symptoms, however mild, either a new continuous cough or a high temperature, then you should stay at home for at least 7 days to protect others and help slow the spread of the disease. Well, I'm not a doctor, but insofar as I'm aware, that went against the guidance of the World Health Organization and the European Centre for Disease Control that was specifying a period of 14 days isolation. The Prime Minister added, "We advise all those over 70 and those with serious medical conditions against going on cruises," that's to say cruise ships out at sea, "and we advise us against international school trips." So what you're seeing here is a rather casual response to the pandemic by the British government and the British Prime Minister in particular. It didn't take until the 25th of March 2020, that is to say a full 2 weeks after the World Health Organization had declared a pandemic, for the British government to introduce legislation, that is to say an act of parliament laying down the law for dealing with the pandemic. They had the reason why it's called COVID-19 is that the Chinese authorities notified the World Health Organization as to the existence of this virus on the 31st of December 2019, and therefore because this virus was born in 2019, it's been given this name COVID-19. It used to be called, at least in the House of Commons, the Wuhan coronavirus, and for political reasons no doubt it's changed its name from Wuhan coronavirus, which is associated with China, to the Coronavirus Act 2020, to coronavirus, hence the name Coronavirus Act 2020. The point I'm making, ladies and gentlemen, is that even though the British government knew from January, when the World Health Organization announced that this virus had been in existence in China since December 2019, even though the British government had from January to prepare for this virus, the British government did not enact specific legislation, that is to say law, to deal with this pandemic until the 25th of March 2020. That was a full 2 weeks after the announcement of the pandemic by the World Health Organization. Now, you might have thought that I'm not making an argument in favor or against the so-called lockdown which followed on the 26th of March. I don't want to make an argument either for or against the lockdown, but what I'm going to draw your attention to is the fact, the legal fact, that the Coronavirus Act was followed on the 26th of March 2020 by the lockdown. So the lockdown was issued on the 26th of March. But what you see here is that the lockdown was enshrined in law, not under the Coronavirus Act 2020, but under the Public Health Control of Disease Act 1984. There was a pre-existing Act of Parliament enacted in the days of the AIDS epidemic, I think it was, in the 1980s, that gave the power to the British government to issue what are called regulations. These are special laws which are made under an Act of Parliament. The British government had the power to act to deal with the pandemic without having to introduce a new Act of Parliament. They had the power under the Public Health Control of Disease Act 1984. So that begs the question, why did they wait until the 26th of March to issue a lockdown? I stress, I'm not arguing in favour or against the lockdown. I'm just asking the question as to why the British government waited until the 26th of March when they already had the power to enact delegated legislation under the Public Health Control of Disease Act 1984. The point I'm making is that the British government's handling of the pandemic has been governed by law. And it must be governed by law because the United Kingdom is a democracy under the rule of law. And that means that the British government has to operate in accordance with the law, but it must have the legal powers to do things according to the law. And what this slide I'm showing to you confirms is that the British government had the power. It had the power. It didn't have to wait until the enactment of the Coronavirus Act 2020. But that's what happened. Let me just step back a bit to the previous slide. We do actually have a legal definition of these terms that we've been encountering over the past few months. In the Coronavirus Act at Section 1, coronavirus is defined as severe acute respiratory syndrome coronavirus 2, brackets, SARS. Somebody's got their microphone on. Can you please turn your microphone off if anyone's accidentally turned it on? Lida, can you hear me? Can I just double check everything's
Yes,
all right?
I can hear you. I can hear you. I have a mute participant. It's fine now.
Thank you very much. So let me just go back. Here we have actually a legal definition in the Coronavirus Act 2020. Coronavirus means severe acute respiratory syndrome coronavirus 2, brackets SARS-CoV-2. But there's a separate definition of coronavirus disease. Coronavirus disease means COVID-19, brackets, the official designation of the disease that can be caused by coronavirus. So I'm not a doctor and I don't really want to give you any medical analysis here, but as I understand it, as far as the law is concerned, COVID-19 is distinct from coronavirus in the sense that COVID-19 is caused by coronavirus. So the two phrases that are often used interchangeably, but the Act of Parliament has clarified for us that there is a distinction between coronavirus, which is a syndrome, and COVID-19, which is a disease. And what this is showing to you, what this slide is showing to you, is that in law, we play with words because words are our tools. If you want to become a bricklayer, bricks are your tools. Bricks are the things that you handle every day. If you want to become a dentist, whatever those things that they put in our mouth are the tools of what a dentist does. Well, in law, our tools are words. It's not me who said that. That was the great Lord Denning, a great English judge. He said that in one of his books. Words are the tools of the trade of a lawyer. And what I'm showing you with that slide is that in Section 1 of the Coronavirus Act, there is a distinction drawn between coronavirus, which is depicted and defined as a syndrome, that's an English word of Greek origin, interestingly enough, and COVID-19, which is a disease. Now, that's enough on coronavirus. I want to finish in 5 minutes or so in order to take questions. But does anybody have any questions at this moment before I go on?
I do.
Yes, please feel free to ask a question.
The reason why they were late to take adequate measures was because they were very busy with Brexit or for other political reasons.
Well, that may be so, Joya, and we are now hoping for a public inquiry to be called by the Prime Minister so that this issue can be examined in depth. Brexit, without any doubt, insofar as I can see, was one of the reasons why the British government delayed so much. There has been a good deal of informed speculation that the British government was following what was called a herd immunity strategy. That is to say that the secret, concealed, clandestine policy that the government was following, allegedly, was to enable the virus to spread across the population to ensure that as many people as possible caught the disease, and as a result of that there would be collective herd immunity developed, which would enable the virus to fizzle out or to become less of a problem. There is considerable evidence pointing in that direction, but the British government denies that that is one of the reasons why they delayed. But this is why we do need a public inquiry. In England, we have a tradition of responding to catastrophes or scandals by holding a public inquiry, normally chaired by a judge or retired judge or a senior Queen's Counsel or other senior lawyer, to investigate what went wrong, why it went wrong, and what lessons can be learned. So my response to your astute point is that Brexit was clearly one of the factors for why the British government delayed, but there may have been a number of other factors. Let me move on, and then I'll take questions in 5 or so minutes again. Let's go to what happened next. Well, what happened next was a catastrophe. The British government was, and what you're seeing here are some of the official statistics that were published by the Office of National Statistics on the 17th of July 2020. You will see that and we have to treat statistics with caution. Let me just emphasize that. Statistics are notorious for being open to interpretation or potentially misleading or apt to mislead. But that's why I've decided to show you the official statistics of the Office of National Statistics, not newspaper sources. The Office of National Statistics, which is the public body responsible for statistics in the United Kingdom, has shown to us that there was a huge spike in the number of deaths in England. That's the 4 columns on the left, and Wales, the 4 columns on the right. There was a spike in deaths involving COVID-19. That's a rather woolly phrase. Those are the deaths in blue. That's as a statistic per 100,000 persons. And then the columns in yellow refer to deaths due to COVID-19. So there is a distinction here to be drawn between the number of people who died having caught COVID-19, but they may have had other causes of death or other illnesses that contributed to their death, and on the other hand, people who died because they caught COVID-19. Now, what we see on this slide is that there was an increase in deaths in March, but look at the deaths in April. And the question is, did the delay in introducing the lockdown contribute to that spike in deaths in April? Did the lockdown itself contribute to that spike in deaths because there were people at home who were too scared to go to hospital to seek treatment, and therefore they died at home? Or were there other reasons why there was this massive spike in April? What we know for certain is that there was a massive spike, a massive jump in the number of deaths either involving or caused by COVID-19 in April. And it would appear that the policies of the British government were directly or indirectly responsible for that rise in deaths in April 2020. The relevance for us as lawyers is that, or law students, is that these deaths and the wider catastrophe that's befallen the United Kingdom and England in particular has generated a mixture of criminal cases and non-criminal civil cases. There are a number of cases that have already gone through the courts that arise from the pandemic. To give you a very simple example, a number of demonstrators have been charged and found guilty of offences of disorder because they've been campaigning against lockdown measures. On the other hand, there have been a number of people who've been who are bringing civil claims against the British government or against ministries in the British government for alleged or actual failings on the part of the British government or individual ministries. So we're going to see over the next few months and years a succession of court cases in both the criminal and the civil spheres, which are a byproduct of what we're seeing in that slide. I'm going to give you a few examples here. Let me just give you the example of the care home sector. Those of you who may remember, earlier this year, one of the slogans of the British government was "Save the NHS." They kept on saying at the daily press conferences they had, "Save the NHS." The NHS is the National Health Service, the equivalent of the Cypriot YESI. Save the National Health Service, save the National Health Service, save the National Health Service. It was this slogan. But the problem with that slogan was that it meant that there was a policy of giving overwhelming emphasis to protecting hospitals, but this gave rise to a failure or an alleged failure to protect care homes, where elderly and other vulnerable people are given care. And what appears to have happened is that the dignity and the lives of thousands of residents of these care homes were both undermined because of British government policy. This is the exceptionally grave allegation that has been confirmed in writing by the Public Accounts Committee of the House of Commons in a report published on the 20th of July 2020. The British government has not denied this. They claim that they were acting as well as they could in the circumstances. They haven't actually denied these allegations, which I would assume are going to be part of court cases that are going to come to the courts in the not too distant future. So let me just read to you this slide briefly. I'll speak for another 3 or 4 minutes, and then I'll wrap up for questions. The government, this is the allegation put by the House of Commons Public Accounts Committee. So it's a special committee of the House of Commons involving members of Parliament from all of the parties, or all of the main parties represented in the House of Commons. The government's slow, inconsistent, and at times negligent approach to giving the adult social care sector the support it needed during the pandemic is illustrated by the decision to discharge 25,000 patients from hospitals into care homes without making sure all were first tested for COVID-19. Remained in force even after it became clear that people could transfer the virus without having symptoms. So what the British government was doing was it was pressurizing the hospitals, it seems, to discharge, that is to say, to release patients from hospitals, to free up hospital beds, to enable the beds to be occupied by incoming people. And those people were being discharged from hospitals and transferred into care homes without ensuring that those persons were given a test to find out whether or not they had the virus. And it appears that as a result of that, the virus spread into the care homes, and hundreds, and indeed possibly thousands of the most vulnerable people in society or died or both. And the report concluded, discharging patients from hospital into social care without first testing them for COVID-19 was an appalling error. Shockingly, government policy up to and including the 15th of April 2020 was to not test all patients discharged from hospital for COVID-19. And that, ladies and gentlemen, is one of the reasons why we see these spikes of deaths in late March and April and early May 2020. We need a public inquiry and court cases to confirm that the assertion that I've put forward is correct or not. But I'm certain that this is going to, and I know already there's one case in the pipeline, that the care home issue is going to give rise to many, many cases. Let me just finish with a reminder that everybody has a right to life that shall be protected by law, and that no one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which the penalty is provided by law. That's the wording of the European Convention on Human Rights as embodied in the Human Rights Act 1998, and the death penalty has been abolished across the member states of the Council of Europe. That's not the European Union, that's the human rights body of Europe, of which the United Kingdom remains a member in spite of Brexit. Here, finally, are a couple of cases, just two among many, many, many that I could show you, as to how how the pandemic, those are the two words of the year, Brexit and pandemic. These are two cases which show how the pandemic has entered the courts. The first is a Court of Appeal of England and Wales case regarding the Debenhams Retail Limited, and that is an appeal concerning the interrelationship between the government's coronavirus job retention scheme and the adoption of contracts of employment by administrators under the Insolvency Act 1986. What the pandemic has done is it is resulting in one business after another going into administration and activating the Insolvency Act. Insolvency arises when a company is earning less money than it's paying out, its debts are racking up, it's unable to pay off its debts, and it needs to go into administration in the hope of either rescuing itself, or if it can't rescue itself, being wound down and ceasing to exist. And Debenhams Retail Limited is an example of a company that has found itself in difficulty. And the tragedy with insolvency procedures, and with the pandemic as well, is that the employment of people is at stake. And what that Debenhams case illustrates is the impact of three areas of law: employment law, insolvency law, and coronavirus law. The three areas of law come together in this case. And there's a fourth area of law, and it's company law, because Debenhams Retail Limited is a company. A second case was Dolan. This was a Court of Appeal judicial review case. The appellants challenged the regulations made in response to the COVID-19 pandemic, and since which introduced what was commonly known as a lockdown in England. That was an attempt to challenge the legality of the regulations, or the lawfulness of the regulations. The challenge failed, but it's yet another example of how the coronavirus has given rise to court cases. So that's my broad brush overview. I asked the question, what does COVID-19 have to do with the law? I've hopefully answered that question, and I'm available to answer any questions that you may have, and also to field any criticisms that you may have, and also to field any expressions of support for the policies and actions of the British government. If anybody wishes to defend the British government, they're free to do so.
Mister, can I ask a question?
Yes, please.
I thought about what you said. So basically, the government knew about the virus spreading long before, so sometime before that. But why didn't they take into consideration that and build new hospitals rather than letting patients leave the hospitals? I mean, I know that it's expensive, obviously, but it would have been less expensive before the quarantine started.
Well, thank you for that question. The British government actually did build extra hospitals. They were called Nightingale hospitals. They were overflow hospitals in case the main hospitals ran out of space. So that makes it even more astonishing as to why they were so desperate to empty the hospitals and to send the elderly people from the hospitals into the care homes. But where the British government appears to have been at fault was by not ensuring that there were sufficient stocks of what are called personal protective equipment in the hospitals, because there was a time when there were doctors and nurses and they didn't have enough of these. They didn't have enough of these, the masks and aprons and gloves and those other shields that they wear. There was a shortage of that. And what makes this even more scandalous is that the British government was repeatedly promising that all was well. And there's a slide that's just one example among 20 or 30 I can show you, where the government was saying that the health service and the country itself were very well prepared. In other statements, they were saying they were extremely well prepared. So the problem wasn't the availability of hospitals. There were enough hospitals available. What was not available during that critical period in March and April were these things: the face masks and all of the other items of personal protective equipment. And even the face masks that were available, were like the ones I'm hanging from my hand now, the flimsy ones. There were doctors and nurses at the time complaining, well, this isn't good enough. We want something a little bit better than this flimsy face mask. But there we go. That's why we need a public inquiry. The advantage of the United Kingdom is that we have an independent and impartial judiciary. So cases can be brought to the courts in confidence that the cases will be heard by judges who will be applying pre-existing principles of common law or statute law, or both, depending on the circumstances. We can be guaranteed a fair outcome to those cases. There is a system of appeals in place in case a judge allegedly or actually makes a wrong decision. And we also have a tradition of having public inquiries that enable the truth to come out. Allied to those judicial, quasi-judicial procedures, we also have Parliament. Parliament is very good at investigating scandals, wrongdoing, and other things that have gone wrong. And hopefully the truth will eventually emerge. It's going to take time. Academics have a role to play, members of Parliament have a role to play, judges have a role to play. Every one of us has a role to play to find out, number one, what went wrong, number two, who was responsible, and number three, perhaps more importantly for the future, what lessons we can learn from this catastrophe to ensure that there is no repetition in the future. So thank you for your question.
Thank you.
Any other questions?
And is there another question? So we can more surely say that there was political reason for this situation?
Well, clearly the there he is. In the United States, there's a phrase that the buck stops with the President of the United States. Well, in our constitutional and political system, the buck stops with the Prime Minister. He is the head of government. He is the one who chairs the cabinet. He is responsible for appointing the Secretary of State for Health. He shoulders the responsibility for the direction of policy. And to his credit, he was standing in the House of Commons defending his policy throughout this crisis. He was chairing the press conferences in Downing Street from time to time. So he took the lead over this. The question is whether his leadership resulted in negligent or otherwise wrong decisions. And by the look of it, one wrong decision after another was made. You may remember that on the 3rd of March 2020, as the virus was spreading across Europe, Mr. Johnson stood at a Downing Street press conference and boasted that over the previous few days he'd been shaking hands with COVID-19 patients in English hospitals. And that was at a time when the European Centre for Disease Control was warning people to stop shaking hands. So he shoulders responsibility for the political decisions. But what I've tried to show you, and I think this is quite important for you to understand, is that law quite often, legislation, let me rephrase that, legislation, that is to say acts of Parliament, are the products of political decisions. That Coronavirus Act 2020 and the regulations that followed on the following day, the 26th of March 2020, they were the products of political decisions. Court judgments are not the outcomes of political decisions. They're the judgments of dispassionate judges applying the law independently and impartially. So common law, thankfully, develops on a largely, I should say, non-political basis. There may be political considerations in the background to the evolution of common law, case law principles, but the judges, thankfully, are not influenced by political criteria when they lay down legal principles in their judgments. Politicians, on the other hand, sadly, are thankfully, depending on your point of view, are driven by political considerations, and that explains the nature and I would suggest the shortcomings of the response of the British government under the Prime Ministership of Boris Johnson. Thank you for that question. Any others before I close? My time is all but up. Is there any last question before I close?
I have a question.
Yes.
Is the UK influenced by the policies of other countries such as the US or other powerful countries, or all policies and political decisions are all taken by the UK?
Well, that's a very good question. Until the 31st of March 2020, the United Kingdom was of the European Union. That was clearly a factor, a related factor. But even after the 31st of January 2020, the United Kingdom was still locked into a close legal relationship with the European Union under the terms of the European Union United Kingdom withdrawal agreement. So there's no doubt that the United Kingdom's policies throughout the pandemic should have been guided by its relationship with the European Union. But for political, I'm not saying that in order to say that the European Union's approach was any better, because look at the situation in Italy and Spain, for example. It was almost as catastrophic as the situation in the United Kingdom. The point, though, is, in answer to your question, the United Kingdom's policies should have been guided by its relationship with the European Union. It appears also, however, to have been influenced by President Trump. Boris Johnson has developed a good relationship with President Trump, and President Trump took a rather casual approach to the pandemic, and that seems to have rubbed off on Boris Johnson. That's why we need a public inquiry. We need a public inquiry because the questions you're asking are all pertinent. They're all spot on, but I'm not in a position to answer them because I don't have access to the secret government documents that Boris Johnson and his ministers were reading and consulting and were using to formulate their policies. That being said, there is sufficient information in the public domain to enable us to make an informed judgment that be wrong, and it looks as if those responsible are the politicians who were operating as ministers of the Crown in the British government. It's 18 minutes past 11. Do we have any more time for questions, Lida, or shall we hand over to the next speaker?
Hi, Claire. In case a student wants to really ask a question, we can allow him or her to do it. If not, we can move to Andres.
Thank you very much, everyone. Bye from me.
So thank you very much, Claire Host, for this interesting presentation. Now we are moving on to Dr. Andreas Marcu, who is a lecturer in EU law and theory. He will present the session entitled Disobedience to Law, Is It Ever Okay to Break the Law? So thank you, Andrea, for your willingness to do the session today.
Good morning, everyone. Thank you, Lida. I'm happy to be here, and hopefully we could have a rather fun discussion this morning. Okay, so hi, everyone. What I want to discuss today is a question that I think is pertinent to any investigation into law and the nature of law, and that is the question of disobedience. This is supposed to be an interactive session, so I'll be asking plenty of questions, and I want you to just express your opinions, whatever they may be, and then we can work through them, okay? So let's start with this. Let's say you're driving a car and you're facing a red light. What do you do?
You stop.
You stop. So you see a red light, you stop. Why do you stop?
Because it would be a criminal offense if I proceed.
Because if you proceed, then you're breaking the law. So what happens if you do that? What happens if you break the law?
There are consequences. You pay a fine.
You pay a fine, right? So one of the reasons we obey the law is because if we don't obey the law, if we fail to obey the law, then we'll be sanctioned. There will be certain sanctions. Now imagine this scenario. Let's say that I'm in the same car. I'm driving the same, not the same street. I'm driving a different street, and I'm driving that street at 3 a.m. in a desert road. There's no one around for miles. I can check, and there's no one there. Crucially, I can check, and there's no police officer on site as well. Should I stop at the red light? Or let's make this a poll. Who here would stop at the red light? Raise your hands. Okay, so we have 2, 4, 5 people who are stopping at the red light. That means we have, what's the total? We have how many participants? 17. So 5 would stop and 12 wouldn't stop. Let's hear from those who would stop. Why would you stop?
A law is a law, whether I'm alone or I'm surrounded by others.
Okay, so let's think back to the first, to your first answer to my question. When I asked why would you stop at the red light, and your answer was because I would be sanctioned, because there would be some sort of sanction. Now in this scenario, I take away the sanction part. So why do you stop?
To obey the law, so there would be discipline.
There will be discipline. Okay, why does that matter? How does my running the red light when there's no one around to see it impact discipline?
Because anything could happen. You can accidentally hit a man that you did not see. You can hit another car. You can hit a bystander. This could harm other people.
Yes, but that's why in this imaginary scenario, there's no one around. Absolutely no one for miles. Clear skies, plenty of light. I turn right, I turn left, no one there. So there's no one there to harm. Why would I stop?
I would say that I'm. Oh, sorry.
Hold on, Eva, go ahead.
Okay. I would say that I'm following my moral obligation, despite there not being anyone there.
So you think that we have a moral obligation to obey the law?
I personally would say so.
Okay, and I think this fits with what Joya mentioned earlier. The law is the law, whether there's anyone there to enforce it, right?
Yeah.
What about people who said they would pass the red light? Why would you pass the red light? Sophie, you have your hand up?
Yes, personally, I would understand the moral part of it, but in my personal opinion, the morals are the same as laws, are made to respect other people's life and their own borders. But when, in the case we have now, there's no borders that can be crossed and I don't harm anyone. So in my personal opinion, I could cross the red light because it's still, I didn't hurt anyone and nobody knows about that. So morality for me at this point that it can be over the laws. In case of something, I would break the law, even though for my morality, it doesn't hurt anyone. So yeah, sort of this way. I believe that
if I understand
choices,
correct, go ahead.
sorry to interrupt. I believe that choices that can be made by me can be over the laws that exist. Even though I agree that we need to follow them to have a quality life with others.
Well, so I think your argument is we should follow the law in general, but sometimes it might be okay to break it if I think so. I think that I could. Is that it?
Yes. It depends obviously on the reason why would you break the law, but if the law says it depends. Yeah. In this case, I would say yes. In this case, I would say yes.
So you think it depends on the reason why you break the law?
Yes.
So you
Obviously.
think that?
Yeah.
Let me give you two more imaginary cases with a same person driving the car, reaching the red light. In one case, he's really late for work. Really late for work. And if he has that red light, he can make that meeting just at the nick of time, just before the meeting starts, right? And therefore, he'll keep his job or whatever. Is that reason enough to break the law?
No.
No, it's not.
Not really.
Sophie, what do you think? Not really.
In this case, no. I mean, because we take into consideration that there are people living their own life. So this is not a reason enough to break the law.
So can we distinguish
But for
between different
example,
reasons
sorry,
to break the law?
interrupt. For example, if he's running late to see the last breath of his life or his wife, maybe that would be more a reason to break the law.
Okay, so I think what you're saying, and I don't know if others agree or disagree, so maybe someone could help us out here, is that there may be cases when it's okay to break the law for some reasons.
Yes.
And that reason certainly doesn't include saving your job.
Yes. It should be
Okay.
higher value than, it should be
Okay.
more universal, I would say, more humanitarian
universal.
rather than personal, rather than self-interest. Yeah.
Okay. Andrea, you have your hand up?
Yes, in my personal opinion, no law is perfect. So there are some cases where logic must be above the law. For example, the example you gave with the red light in a desert road. What's the point for me to stop? If I stop, that doesn't mean that something changes. If I pass a red light and I break the law, nothing changes at all. I win time. I will not run late. I won't stop in the red light. Basically, you have to use your logic, because sometimes what's the point for the red light in a road where there are no cars? There's no point for a red light to be in a road where no cars pass from there. So why do I have to stop in a red light in a road that there are no car passing from there?
Okay, so I think we have two hands up. Maybe they're in response to you. Joya, please go ahead.
Yes. Actually, it's his mistake if he overslept or if he was late to move from the house. So he has to be responsible for his mistake and respect the rights of others. And perhaps there's a car that will pass by. Pass in front of him instantly, and he won't notice. So he's here exposing his life to danger and the life of others to danger. And this is why the law is made, to protect our rights and the rights of others. So I think that here it's obvious.
Okay, Eva?
My response is in regard to what Andrea said. Well, why is there a stop in a deserted island, in a desert street? He has a good point of why should you stop there and not just continue to save time. But if I personally were to see that stop and it had the red light, I would stop, because I know if I passed it, it would stay with me, and it would like a little voice would tell me, "You passed that red light. What makes you think you won't pass it on a street where it's it is a red light, but there's more cars, and you're late for somewhere, and you know you did it before, so do it again."
So Eva is raising a very conscientious point, right? And we can all agree that society would have been much better if people were a little bit more conscientious. But let me get back to Andrea's point. So what he's saying is that sometimes you just have to use your logic. Don't obey the law, just use your logic, right? Is that how the law works? Does the law ask us to use our logic? and our common sense maybe, or our sense of justice, whatever that might be, or our fairness, or our conception of what's good. Does it, Andrea?
In my opinion, we elect representatives who share the same logic and the same sense of justice with us to go to the parliament and vote for laws that share the same sense of justice and logic as we do for our purposes. We want to use the laws. So what's the point to have a law if a law restricts everyone and no one likes to oblige to that law? There is no point to that.
There's no point to that.
If we vote for a law that no one likes in a government, in a country, there's no point of following that law, and that's why we have to reform this law and maybe change it.
Okay, what about a law like this? We have a law saying that we must wear masks all the time. No one really likes it. Sophie, you have your hand up?
In a way, this law sort of contradicts with the rights of human being to be free in their sort of way. And as my knowledge, as I know, in some sort of way, the masks are made just to show the series of situation rather than to prevent something. But in this case, also, if it's more beneficial for the society to wear them, in whatever reason it is, and my self-interest are my own idea, then obviously it's easier to wear a mask, though I personally believe that it just contradicts with the rights of human being to do whatever. It still kind of puts pressure on the person. Yeah, so I don't really agree with the masks.
But do you wear it?
Yes.
Do you simply wear it because of the fine?
No, I simply wear it not to meet, I guess, the social demand of them. It's just people are getting used to wear them. Yeah, so here more
so
like
it's social pressure.
Social pressure comes on it. And also habit, which is quite sad.
Well, it's not really sad. I mean, Aristotle said that law is about habit. The whole point of law is that it instills habits. Good law creates good habits. And so you end up doing things that are good simply because there's a law. And even if the law is amended or changed, then you keep doing things that are good. So for Aristotle, law is all about habit. It's all about creating good habits. 3 people with their hands up. Andrea, go ahead.
Again, in my opinion, the law about wearing masks is very logical because it's about social protection against the virus. But again, if I use my logic, when I am in the car with my friends, the law says that we have to wear a mask. I know that my friends do not worry about the virus. So what's the purpose of wearing a mask and while driving when my friends and I do not care about the virus while we are together? When I'm outside in a cafe or anywhere else, I wear my mask because that's the logical use of the mask, to protect the people that need to be protected. That's what the law has to say. If one doesn't care about the virus, what's the purpose of wearing a mask? That's my opinion.
Let's see if there's a problem with this approach on the law being logical. We've heard Sophie saying that essentially she doesn't really think it's logical, right? She thinks that it doesn't really do a lot to protect. She wears it because of social pressure, so not because of logic. She wears it because of the fine, again, not because of logic. And you come here telling me that you think it's logical. So we have 2 people. One thinks that you should obey the law because it's logical, and the other one saying that you shouldn't obey the law, or saying that you should obey the law, but even though it's illogical. So how helpful is this idea of the law being logical or reasonable, we might say, or just or fair or whatever? Yes, Andrea, go ahead.
That's the whole point of democracy. Some people say that it's logical and you have to follow it. Some people say it's not logical. I don't want to. The whole point of democracy is for the majority of people what think is logical and justice to be followed. So even if I agree with the mask, the majority do not agree with the mask, we should follow the majority because that's the whole political system of democracy. But
isn't that a little bit different from what you told me earlier? Because with this example here, wait, hold on. With this example here, you told me that you use your logic and you cross the red light.
Yeah.
So what I'm getting at is when you have a law, maybe you want to add the caveat that when that law is democratic and you have a law, what you think is logical or just doesn't really matter. All that matters is that there's a law.
In certain circumstances, for example, if I pass a red light, there are no consequences because I won't hit a car because I'm sure no one will pass. If the road for miles there are no cars passing by, nothing will happen. But if I don't wear my mask in a cafe, if I have the virus, others will later get infected with the virus. So there is a what's the consequence,
distinction.
Distinction and consequence if I don't wear my mask, and whereas if I pass the red light, that's the morality I think the law should be followed.
Okay. We've got 3 more people who want to talk. Let's see, from the list, Joya is the first one. Go ahead.
I would like to argue that no one knows how logical or how intelligent he is. So we can say that logically speaking, there's no standard for this. And the standard here is that it's a pandemic, it's an emergency. I have to protect my right to life and the right to others to life. So why I have to base my logic or my rationale on my intelligence when I don't know how intelligent I am? Or why I have to expose the lives of many others and perhaps of many old people or people that are really vulnerable to the situation, to this danger, just because I think that this is what my logic says, and perhaps my logic isn't true or isn't really applicable for everyone.
Good. Thank you. So, Sophie, you want to add something?
Yeah, I obviously any decisions cannot please everyone, and I believe that laws are still made for the benefits of groups of society. But at the same time, there are laws that aren't logical on their own. For example, in Cyprus, the law that you cannot meet, okay, it was when it was quarantine, that you cannot meet outside more than 2 people, but at the same time in the house, it cannot be more than 10 people, which doesn't make sense, really. Yeah, and also wanted to add the point that even outside, I can assume that the law was made to be benefit for society. That's why I will follow it. But many people, even though elder people, they do not follow it, which also contradicts with the how to control the law on the first place. I saw many people outside, other people that do not wear masks, or even the police who really crossed the point of gathering. They were in the cafe and all that stuff, which it is kind of breaking the law, but how to see the right choice in it? Yeah, it's hard.
It is hard. That's absolutely true. Eva, would you like to say something?
I just want to mention, in addition to what Joy and Andres overall said, that you need to protect the right to life, you need to protect the vulnerable people by wearing a mask. Therefore, I'm on their side that you need to wear a mask if it was proposed by the officials in order for you to protect vulnerable lives, which just refers to you. No, let me rephrase that. By not wearing a mask, you do a bigger injustice by you choosing to wear a mask, which is an injustice on you personally.
Okay. Let me see if I can rephrase that. So
yeah.
The harm of disobedience, of you taking your mask off, is higher than the harm of obedience. The harm of obedience being your violation of certain rights and freedoms, yeah?
Yes.
Okay, good. So, thanks everyone for your comments. Would anyone else like to say something on this? I think that during our discussion, we've managed to touch on some very, very important issues related to obedience and disobedience to law. First of all, the law, or the existence of a law, claims to preempt our personal judgment, right? So when we have a law, what it essentially says is that do what I say, not what you think you should do. That's the function of law. The question of obedience is a question of whether what the law is asking me to do is something that I shouldn't do. And here we have, Andreas used the word logic, I'd rather use the word justice, right? So in some cases, we might personally feel that there is some injustice taking place if obedience is realized. Yeah, I think we can all agree that disobedience cannot be morally justified if it's simply a matter of convenience, right? You can't morally justify someone's disobedience if they do things simply because they want to get more money or because they want to get to work on time or anything like that, right? You cannot justify theft because a person wants more money, for example. So one of the questions that I want to discuss with you today is what are some circumstances under which we can actually break the law? And when I say we can break the law, I mean we are morally justified to break the law. The law doesn't like being broken. That's why the law has a system of enforcement that includes police and a system of adjudication that includes the courts, right? What the job of that system is to make sure that everyone obeys the law. Everyone does as the law commands. So the law will always frown upon people who disobey, no matter why they do it. Sometimes the reasons why they do things might be a reason for their not suffering certain punishments or certain consequences for their action, right? One example being that if I am on a red light and I have my wife giving birth on the back seat, then we would be morally justified to break the law, to break the speed limit or cross the red light, and the law would probably not impose any sanctions for our actions if there is some higher need, right? Necessity, for instance, or whatever that might be. So let's have a look at circumstances under which people might be morally justified to break the law. Okay, let's skip this. We don't have much time. Yes. So the first example I have here is Antigone. Antigone is a Greek tragedy. And does anyone know what the topic of that tragedy is? Eva, yes?
Yes, I'm aware of the topic.
And would you like to tell us what it's about?
And if you had to summarize it, Antigone is the protagonist in the play, and she is denied by the ruler, the king, by one of his decrees to not bury her brother who died because he committed a heinous act according to the king. And Antigone, she refused his decree and instead buried her brother and was willing to accept the punishment because she argued that she was following a bigger law than the man-made law. She was following a higher form, which was natural justice, as described.
Good. So, very briefly, the story. Antigone had two brothers, Eteocles and Polynices. Long story short, one of them became king of Thebes, and the other one left and returned with an army to take over Thebes. The brother who returned with an army was defeated, and during the battle, both brothers were killed. They killed one another. Now, the new king of Thebes, Creon, who is Antigone's uncle, issues a decree saying that Polynices, who attacked Thebes, is a traitor and should be left unburied, whereas Eteocles, who fought for his country, should be buried with all honors. And what Antigone does is she breaks the law and buries her brother. Do you think that Antigone's actions are morally justified? Andrea, yes.
Yes, I think they are very moral what he did because what she did because the previous king, her brother, had different laws for his city. When the new king arrives, he changed the laws. So what she did, if her brother was still alive, would still be moral. Every time a government nowadays changes, the laws change too. So that doesn't mean
hold on, Andrea. I think you're making this more confusing than it is. It's not a case about changing the law or changing the law from the previous king to the new king. It's a clear case of the king tells you, don't bury this person, and Antigone breaks the law and buries that person. So it's clear that in this case we have a simple case of one order, a legal order, and disobedience to that order. Okay?
Mm-hmm.
So my question is, do you think that Antigone's disobedience is morally justified? Was she right to disobey the order not to bury her brother?
Yes, it was moral because it was her brother and it was a part of the royal family sometimes. So she had the right to bury his body.
Well, yes, not because he was a part of the royal family. That made no difference. Even if they were a commoner, Antigone would have buried her brother, right? Because what Antigone is saying is that leaving people unburied is against the law of the gods. Leaving people unburied is unjust, right? So what Antigone is saying in this case, what we have is a clash between a law directing some action that is unjust and disobedience rectifying that problem. Right? So disobedience for justice. Yes, Andrea, go ahead.
To be exact, in the ancient Greece, the morality came from the gods' laws. So a person, a hero, and in this case, her brother was a hero because he stand up with braveness to fight to gain his throne. He had to be buried and by the rule of gods. So the morality.
No, Andrea, let me clarify something. it doesn't matter why he fought. It doesn't matter that he fought to gain his throne. It doesn't matter if what he did was just or unjust, right? Morality required that everyone is buried, no matter what they do. Even the worst criminal should be buried. Yeah? So what Antigone is saying is that burying a dead is what morality requires, is what justice requires. So in this case, we have a clear example of the law requires some action and disobedience taking place as a response to the injustice that the law would require. Does it make sense? Is that clear?
Yes.
Yeah? Okay, let's move on to other examples. Does anyone know who this person is? That might be a little bit too difficult, is it? So, this person is Harriet Tubman. Do you know the name? Does it ring a bell? Harriet.
Yes, I know her.
Tubman. You know her?
Yes.
Yes?
I think she was advocating for black rights or for slaves. For
Good.
slaves.
She was an abolitionist. So
Yes.
she fought for the abolition of slavery. Now, we don't have much time to talk about Harriet Tubman in detail, but very briefly, one of the famous actions that she did was this. As you may know, back in the United States, slavery was lawful, and there was also a law saying that it was illegal to help slaves escape. What Harriet Tubman did was she broke that law and she helped slaves escape. Now, again, what we have here is an example of a law being unjust and disobedience coming in to serve justice, to promote justice. Yeah. Famous examples of such disobedience also include Rosa Parks, who was a main figure of the civil rights movement in the US, trying to gain rights for Black people in the US, who refused to give up her seat. So she refused to follow segregationist policies. Same with this person right here, Martin Luther King, who fought for justice. The reason why I have all these figures here, and we don't have time to go into that in too much detail, is because it appears that sometimes disobedience is morally justified, breaking the law is morally justified, because the law has some action that is clearly unjust, manifestly unjust. All the examples that I have provided, all the historical examples that I've provided, are cases where the injustice is so clear and so obvious that disobedience is used as a way to change the law, as a way to change certain laws that that promote injustice. A contemporary example of disobedience is, I don't know if you know of Extinction Rebellion, but Extinction Rebellion is a movement that claims that current government actions harm the environment, and that harm is so unjust that disobedience is justified. So what they do is they engage in what we call civil disobedience. Civil disobedience is the deliberate breaking of the law in order to change the law, in order to bring attention to some injustice that warrants obedience. All the examples that I've discussed are cases where the law asks us or asked other people to do certain things, and individual citizens or non-citizens who are trying to become citizens disobeyed the law because they thought the law was unjust. So, having this in mind, let's return to this example. Do you think that COVID-19 related rules and laws are such that warrant or justify disobedience? What do you think? No, why not? Eva?
Agreeing with Joya, I don't think it justifies disobedience in regard to the COVID-19 regulations. I think COVID-19 is could be separated, or it could be differently compared, for example, to the civil rights movement that occurred.
Mhm.
Because COVID-19 is, as your virus that can cause mild or severe respiratory problems, or even worse.
Mhm.
And because it's a threat to your right to life, it's confusing because you need to protect lives and at the same time understand where there are limits, such as your individual freedoms.
Good. Okay. Anyone else would like to say something? Because we're running out of time and I'd like to wrap things up. Sophie, yes.
Maybe to continue what I said earlier, it is right now about saving the health, but I believe that some laws that were, for example, when the first quarantine, where we had to reply when we go out, to why we go out, these are kind of contradict with the human rights to be free to go somewhere and do something, even though it might affect health. So it also depends on the reason why government made this law, if it's to control people or rather control the virus. It's difficult question at this point, but I believe it can be both sides. It can be both for saving for human rights and against them.
Okay. Let me conclude by very briefly kind of wrapping up all of this. First of all, since Sophie mentioned human rights, limitations on human rights are legitimate, right? They can be legitimate. So there are legal instruments that explain how and when legal rights can be limited and under which circumstances. Typically, human rights can be limited if there is some rationale, some substantive rationale, in this case, public health. If the limitation is prescribed by law, so it's not arbitrary, it can be found in law, which is the case with these measures. And crucially, if those measures are proportional, right? If they're necessary to achieve that end. And of course, limitations cannot limit the core of the right. In the case of the COVID-19 measures, there will always be a discussion about whether or not they are legitimate because they are proportional. And I think Sophie is correct to point out some inconsistencies in the way the measures work. But what I think it's crucial to remember is that the examples of justified disobedience that I've discussed are cases where we are facing some substantial injustice, right? That is so severe that disobedience is morally justified. Now, I'm not saying that those are the only cases where disobedience is justified. I actually think that they're not. I think that there are many other cases where disobedience can be justified. But in a case where there's reasonable disagreement in terms of proportionality, it might be the case that disobedience may not be morally justified, right? Because, as I think it was Andreas who pointed out earlier, within a democracy, it is reasonable to have disagreements about how we should behave and when we should behave in certain ways and so forth. The critical part of a democracy is that we are able to voice these disagreements. So the critical part of a democracy is that we can discuss these things in public, we can contest, that is, take them to courts. And this is something that Claire has pointed out in his discussion earlier, right? The importance of judicial review, the importance of being able to challenge governmental decisions. Whether or not actions on government are so severe that they would warrant disobedience, that's a separate question and a rather more difficult question. And with this, I'm going to conclude because I know that I was supposed to talk until 12 and it's already 12:02. So thank you for the discussion. Thank you for participating in this session. If anyone else has any questions that they'd like to discuss, I remain at your disposal. Whenever you want, you can contact me and we can discuss these issues. Lida, I'm going to leave this with you now.
Thank you, Andrea, for this interesting session. That was really interesting. I would like to thank everyone who joined us today and participate to our activities. It was a great pleasure to see our current LLB and LLM students, as well as external students from a variety of public and private schools. We know that this time of period is very, very difficult for all of us, especially for you students, as COVID had and still has a significant impact on your education, and especially on your decision in regards to what path you would like to choose for your future career. As a result of this, as educators, we have the responsibility to provide you with opportunities to learn and find out about the variety of options that exist to choose for your future. And that was the main aim of our today's law fair, to give you an understanding of some of the areas of law and give you an understanding on the various areas such as murder that Nasia mentioned, the impact of COVID on the law, as Claire has mentioned, and the disobedience of the law, as Andreas mentioned. This is the 5th time we are organizing this event, and despite of COVID, we have decided to organize this event in order to give you this opportunity. So one of the options and most popular ones for students to choose for the future career is, of course, to do what we call an LLB. The LLB degree provides you with significant knowledge and skills relevant for any career you may choose to follow, because with an LLB, you can choose the path of becoming a lawyer. If you want to work in the UK, you can either choose to become a barrister or a solicitor. There is no distinction in Cyprus. But apart from that, with an LLB degree, you can choose to follow a career in banking, a career in business, a career in human resources, a career in various positions offered by the government. So it's a degree that can be used for a variety of areas. It's not just a degree just to become lawyers. So it's So by obtaining an LLB degree is a strong actually paper for you to have, which will help you do a variety of things for your future career. Why is that? Because through an LLB degree, you can develop relevant skills such as critical thinking, analyzing, advising, negotiating, team working skills, presentation skills. And these skills are not only relevant to become lawyers, are actually relevant for all jobs. And you will see them in a lot of applications as key requirements to get the job. So the advantage with the LLB degree, specifically at Uclan Cyprus, is that we do offer a degree which is recognized in both Cyprus and in the UK. Therefore, someone who will study the LLB degree at Uclan Cyprus, you will be able, after finishing your degree, to apply to work not only in Cyprus, if you don't want to stay and work in Cyprus, but also in the UK, as it is a law degree which is recognized by the professional bodies in both Cyprus and in the UK. So let me share my screen to you to show you where you can find the LLB structure and what modules we are currently offering. Please note that the LLB modules that we are offering are subject to changes. So let me share my screen for you very briefly, and then after that, you can ask me any questions you may have about the LLB degree. So in case you want to find out more about the LLB, what we offer, you click on our website, which is uclancyprus.ac.cy, and then you click study, and then School of Law. And then if you scroll down at the right, you will find what is called the undergraduate degree, which is a Bachelor of Laws LLB. And then you will be able to find a variety of information in regards to the LLB. Particularly, you can see here we have the modules that we offer every year. We have compulsory and optional modules. In the first academic year, we offer, for example, modules like public law, which is about the Constitution, contract law, which is about when you enter into a contract, what happens when you breach that contract. We offer modules like the legal system, when you learn about the system, how the courts work, what are the differences between a civil court and a criminal court. We have this very interesting module, which is called Lawyer Skills and Personal Development. This is taught by academics who have actually worked as solicitors and barristers, and they have a great knowledge to show you and help you actually enhance the skills relevant to become lawyers. And then we have modules like the Introduction to Academic Study, which is a module which helps students improve their writing skills, learn about the key requirements of when writing an essay, how to reference sources, how to find sources, and etc. And then we have the Foundations of English and Cypriot Law, because as you know, the Cyprus follows what we call the common law, and because of the British colony, we follow a lot of UK cases. So we have great similarities with the UK law. Therefore, we offer such a module in which you can see the similarities and you can see the differences as well. And then we do offer, as you can see here, a variety of optional modules. You can find modules that are focusing on human rights. You can find modules that are focusing on company law, commercial law, medicine and the law, EU law. So we do offer a variety of optional modules. But bear in mind that those modules are subject to change. So maybe for the next academic year, we may have some extra modules or different modules. So what do we need? Some of the key requirements, key entry requirements that we require is for the students to have 16.5 Apollydirion. And we need IELTS, which is 5.5. We do have some students who may have lower IELTS, but if we do have such students, we usually ask them to do what we call the English language course, which is an extra from the LLB degree itself. So if you have any questions about the LLB at Uclan Cyprus, how it works, what kind of modules we offer, you can email me. You all have my email, okay? You can email me whenever you want, and we can further discuss. We can book an appointment. However, if you have any questions now, please feel free to ask me. Any questions?
Why do these modules change from year to year?
Because every degree goes into what we call validations, and also because of the demand of the students. Some students 1 year may prefer to do more oriented company law areas, whereas other years we may have students who are more human rights oriented students. So it depends actually also in regards to the market. And so that's why the modules sometimes are changing. Any other questions? So no questions, I suppose. So thank you very much, all of you, for joining us today. And I wish you all good luck with your studies, even if you are first year students or final year students or whatever. So I wish you all good luck with your studies. And in case you do have any questions, please let me know. Thank you very much. Bye-bye all.